Hi, we're ready to restart, and this is going to be a tremendous opportunity because as we've already seen over the last 2 days, this book, Mark's book, has really elicited a lot of conversation and really a lot of different threads. So I'm Ruti Teitel, and I teach here at New York Law School, and we started our conversation last night over my book, and so now I get to retaliate, right? No, we're going to allow Mark to respond about 20 minutes, something like that. And then we'll open it up to the audience since we know there's so many interesting thoughts as well that continue. So over to you, Mark. Yeah.
Okay. First, very much, lots of thank yous. In particular, Penny, to retain, and to everyone at New York Law School. And I think, as most of us know, the main reward we get as academics is twofold. One, people taking what we say seriously, when we're not really sure this is being taken seriously. So first, if I could do the clapping for all for just the appreciation of taking some of the ideas in the book seriously and taking them not simply as, I think this is right, this is wrong, but taking them seriously as, here's how I might rework these ideas for what I'm really interested in. So, how might they play out in South Africa in 1950, Brazil, in affirmative action, litigation? Inevitably, you discover that they're no longer fully your ideas. They're sort of, a weird amalgam. But I had a basketball coach who had an expression I love. He said, sometimes he said, I don't feel you in this game. And for those who are you sort of know, you're out there on the floor, the game is going on, and sometimes with Draper, I feel you in the game. And I felt myself in the game for a day, and that was just an absolutely wonderful feeling. And I hope you read this book, people at least I knew for today, you felt yourself in the game, because this book could not have been written. Even the comparative perspectives from Penny, from Hyde, from Garib, these perspectives, the importance of the civil rights issues, from Rebecca, from Hank, from all of you, and Sandy and Jack, this has been discussed over there. They are so sick of it that they're still here. Even sometimes you're not acknowledged. So someone pointed out the book begins with a joke about a character in Hamlet called Osric. It is a French family joke, not a Graeber family joke. It's a joke I learned from my wife. She doesn't get footnotes, but like it or not, I mean, her presence in both my life and the book, it just makes it all valuable. I begin with another story, true story. And for me, it's a formative story. I hope you'll see the connection of the book. It's about 48 years ago, and I have been asked by the dean's office to get a student council vote in favor of Dartmouth going to sex-blind admissions. At the time, they agreed Dartmouth could go co-ed, but you couldn't reduce the number of men. It's not a little housing problem. So you had to have 3,200 men, and the university worked out a system you could add between 800 and 1,000 women, and that did not work out for all the reasons everybody you can think of. And they were having tough sledding with the trustees, and they went to the student bodies for the trustees said, no, and my job was to get that resolution through the student government, which I was a big part of. And here's an interesting feature of that meeting. None of the radical groups on campus were there. They did not know this meeting or this vote was taking place. But in the audience was a fairly sizable group of women from the two sororities that we had. They learned about the meeting. And I will tell you, about 10 votes switched, and we got the resolution. Now, here's the connection in the histories of co-education at Dartmouth. In the histories of co-education in many places, we tell a very clean story. Women fought for co-education. They fought against odds, people treated them poorly, but this was an idea that could not be resisted in the long run. There was opposition politics on one side, but what there was on the good side was we are for right and justice, and right and justice wins. And I deeply suspect that in colleges across the country that were once primarily male, stunts like I pulled to get a favorable vote occurred. And so the lesson is not simply the lesson that Jack left us, which is that the difference between the 14th Amendment and competitive authoritarians is the values Republicans fought for were good values. But one of the lessons of the book, very much for students, is you have to fight for good values through politics. It's not to say politics has no limits, but one of the features of Abraham Lincoln, we know, is Abraham Lincoln was a party organizer. Abraham Lincoln put coalitions together. Abraham Lincoln write letters to people saying, I know the tariff is an important issue. If we bring up the tariff, the party collapses. That good things are fought through politics, and one of the things I think we do worse on my side of the fence is we give politics a bad name. Being called as I was a student politician, that is not. And I want to you that one of the features of the book is Republicans were engaged in politics, and because they were good at it and they were better at it than some northern white supremacists, that's why we have an amendment banning slavery. That's why we have a 14th Amendment. That's why we have the degree to racial equality we have, not simply because the ideas are good, because at certain crucial points in history, the people doing politics on the side of the good were better than the people doing politics on the side of evil, and one might argue our present circumstances are caused by the people, in my judgment, doing politics on the side of evil, doing it better than the people doing politics on the side of good. One contemporary lesson is we need to get better at doing politics. We need to get better at understanding the way constitutions work, which is a central theme of this. That in law school and in common things, we're told constitutions work by limiting government. They work by taking the white supremacist and saying, guess what? I know you believe slavery is a good thing. I know you believe the white race is a superior race, but darn it, tough luck. We got a constitution that says no slavery, and you've got to treat people equally by race. And they will, I said, yeah, yes, you're right. Too bad, until we can amend the Constitution. And when you say it, it's stupid. But this is what we teach. As I want to give you 3 other ways. Book. We've discussed today, constitutions work. First, rather than think of constitutions as instruments that constrain the unsympathetic, think of them as instruments that empower the faithful. So, for 80 years, most anti-slavery advocates, a few abolitionists to the side, but even Charles Sumner, Abraham Lincoln, that kind of anti-slavery advocate, say the Constitution does not permit the federal government to emancipate the slave in an existing state. They say the few radical abolitionists disagree. They are just to the side of politics. But now we're talking about characters who are mainstream. They are sitting in the Senate. They have a block of votes. They have a block of votes in Congress. They have a party. But having said that, during the Civil War, they had real qualms about freeing slaves, particularly in places like Kentucky, Maryland, Delaware, and Missouri, which haven't seceded. Why does the 13th Amendment work so well in Kentucky, Maryland, Delaware, and Missouri? Because it says to people who don't like slavery, now you can get rid of it. In other words, when the Constitution, rather than saying we're going to disempower the bad guys, is right now we're in office, we have qualms about exercising powers we think are good. We're going to give us the powers to do good. And when a Constitution does that, works wonderfully. Second and most important, and this is going to be the subject of the next volume, constitutions work by configuring politics so that some outcomes are more likely than others. As a number of people today have observed, the main impetus for the 14th Amendment is not the black codes. Republicans thought they had the power to deal with the black codes in the 13th Amendment Section 2. The main impetus is the 13th Amendment appears to give former Confederate states 30 extra votes in the House of Representatives and the Electoral College for freed African Americans who do not vote. And as long as they get 1/6 of the northern votes, they're doing much better than that among Democratic. They will control the national government. If they control the national government, Republicans, right? Have you read this book by Graeber? If you read the book by Graeber, you'll know that white supremacists in charge of the national government will find a way to return slavery. The only question we have is whether they'll call it slavery or not. They might call it something else, but it will be slavery. That what we need to do is take rules in our Constitution that favor slavery and make them favor free coalitions. And by the way, what Republicans, it was wonderful, is in fact that they're actually rules are, by the way, fairer. It's not simply they benefit us, they are fair. And if we look at constitutions throughout the world, the structural provisions are never neutral. There are always efforts to bring about kinds of results. Sometimes it's through kinds of results. If we vote this way, there'll be buyers to pay for building canals. Well, fellows, if we vote this way, Harvard graduates are more likely to be in the Senate than someone who's a cop. And we think Harvard graduates have different interests than cobblers. Last and most was a point Penny raised, that one of the most important points that constitutions do is constitutions are consistent. One of the things in orthodox political science, which too much law gets, is a belief that people bring their interests into politics. And what happens in politics and law is we aggregate those interests. In fact, what happens in politics is interesting values are created. So one of the things the Republican Party does in the 1950s is the legislative order starts off by, slavery is really bad for African Americans. And the ordinance goes, yeah, you're probably right. It's with that degree of enthusiasm. And now I'm going to tell you why slavery in the South is bad for you. Because of the slave power, we don't get to build our canals. Because of the slave power, when you move west, your wages are going to be lower. And suddenly there's a Republican Party interest. And by the way, as African Americans fight in the North, you see support for African American equality zooming to the point where in 1885, what is the most racially egalitarian interest group in the country that's not simply an African American interest group? The answer is the Grand Armies Republic. That the people who fought with African Americans became racial egalitarians for the rest of its life. And it's not accidental that we become fully committed to Jim Crow 1890s, 1900s at a time where this generation dies off. So say about the education function, sticking no slavery, and this is what Section 1 is doing. It's not doing law. They've got the law already. It's sticking it. This is what we mean by no slavery. We mean by no slavery a person who is a citizen, a person who is equal, a person who has due process rights and enjoys the privileges and immunities of a citizen. So one of the crucial features of Section 1 is it takes the abolitionist anti-slavery creed, which they believe was in the 13th Amendment. Every Republican had no problems with the provision of the Civil Rights Act of 1866 that said African Americans are citizens passed under the 13th Amendment. But it now puts it in paper. Understand, there are immigrants and there are citizens, and there is no class in between. Everybody is a first class citizen. And again, it's not for the Supreme Court. It's for socialization, but it's also the understanding that hopefully these amendments will create more people who are committed to them. If, as Henry Paul said, if we get rid of the Southern elites who've been running the newspaper, we will have an educated system that creates more people who are committed to different versions of racial equality. So this is how constitutions, I think, work. I think, as we all know, the Republican framers got the mechanisms wrong, in the sense that the things they thought would work to create a country more committed to racial equality, they made mistakes, some of which I'll talk about in this book, some of which I'll talk about in futures to come. But they got something, I think, fundamentally right that we lost with the Warren Court. We never examined the political foundations of the Warren Court. We just said, well, courts are magical places where when you make good arguments for progressive things, they do so regardless of the rest of the population. And by the way, we're going to ignore the fact that for 200 years, courts have never done this. But the Warren Court is the real court, the rest of history. Okay. Brown versus Board of Education just trumps every other case decided by every other court. One of the things I have a little piece coming out, I'll recommend is a little challenge. Think of a case decided before Bowling versus Shaw, which declared federal laws declaring segregated schools in Washington, D.C. unconstitutional. From 1791, when the Supreme Court first sat, to 1954, when Bowling is handed down, where the Supreme Court court declares a federal law unconstitutional, and you think 80% of the people in this room will say yes. And by the way, 80% of the people in this room are not deeply committed to whether Section 13 of the Judiciary Act of 1789 is constitutional, because unless you taught civil procedure, you have no thoughts about whether original or appellate jurisdiction in this particular instance matters. They always highlight to my class. How many of you, when you simply read the facts of Marbury, cared how it came out? Nobody. We don't either. But on the other things, right, Dred Scott, wrong. Civil Rights Act of 1875 declared unconstitutional, wrong. Legal tender declared unconstitutional, wrong. Income tax declared unconstitutional, wrong. Most New Deal declared unconstitutional, wrong. So courts are not this magic place. Now, this is not a Jerry Rosenberg courts are a hollow hope. It is rather courts do good things for you. When you first do good things that put your people on the court, and sometimes it's a coalition. Sometimes, by the way, when politics is divided, if both parties, as was the case in 1940, have other things that agree with each other, you get something like the Warren Court. But it's still related to politics. And our constitutional law has lost that. Our obsession with Section 1 says good news. The framers wrote rules for us, and if only we can get institutions that follow the rules they laid down, we can do this. Republicans knew that was wrong, both radicals and conservatives. Section 1 is the guideline as to whether affirmative action is unconstitutional. It's not a guideline for whether schools should be segregated or whatever. It is rather a set of values entrusted to people committed to racial equality and free labor, and says, go pursue them as best you can under the conditions of our time, keeping in mind to keep the power, you must persuade others you want to have power. It's time we need now, not for court decisions. Now we need to persuade others. As I hope on this I have persuaded. Thank you very much.
Great. Thank you so much, Mark. And so we now have, what would you say, about 15 minutes? If we go over a little, go over a little bit for questions and comments. Let me just take the prerogative of the chair and just add a question that I had. We've had a very long and really rich day. So I was wondering, this is a vocabulary question, because I think part of what you're encouraging us to do, and I certainly, obviously there's a lot of overlap between our books, not just presidential Reconstruction and, other congressional Reconstruction, but really about focusing on the transformative aspects and the idea that what we're talking about is not rights versus structure, which has come up a lot of times during the day, but rather it's about creating a new political community going forward, and that's really the work of the 14th Amendment. And so it's not that the Section 1 is opposite to the other parts of the amendment. At least that's how I understand you. But I just wondered, I wanted to volunteer another kind of a vocabulary point, and I wonder if this is friendly to you or not. And that is, in some parts of the book, you talk about the constitution of memory, and that this is how a lot folks interpret the Constitution, and versus a presentist constitution. And that now, we're not remembering what you have urged us to remember, right? And I wonder if we could add some pieces to that puzzle and think about a constitution of transition. And this has come up, some of the speakers in the last two panels. And if it's a constitution of transition, at least with respect to the 14th Amendment, and I would say that there are analogs in the 1789 Constitution with respect to, anti-royalism and certain states' rights, ways to think about moving from, the prior arrangement, whether, think King George or the Articles of Confederation, that there are parts of the Constitution that were very important then, that were about the transition. And then the question becomes, because that wouldn't be the end of the matter with respect to the 14th Amendment, the sections that you're focusing on, about lustration, which, is the term we use in transitional justice, restructuring the civil service, restructuring the government. If we think about that part of the Constitution as Constitution of transition, then we add a vocabulary, which is then we can think about or discuss, and we can galvanize. Did it happen? Was it abandoned? Was it wrongly, was it misapplied, not enforced? I really, we talk about this in transitional justice. We talk about transitional justice postponed, or, elided, or, betrayed or forgotten. And so, and you mentioned forgotten, but I really think that this idea, and there are other parts of the Constitution as well that relate to the transition. But for example, the age of the president in the 1789 Constitution, we know relates to, who you want in the political community and not wanting, or people being born in the country, right? That you shouldn't have kids of royalists and so on and so on. There are ways that we can look at the Constitution and see that there are transitional dimensions to it that, may have been honored in the breach, or values that are important going forward. I just wanted to throw that out. It's something in between a constitution of memory and a presentist constitution, where, we just no longer see the value of those sections. And, if the sections are about creating a dynamic and transformative political community that is about equality, right? It is committed to equality, committed to inclusion, then this gives us a vocabulary for today. And, I think that, as you say, the other side sees it. A lot of the, anti-birther, et cetera, they are all about shaping the political community in America going forward in a direction that is opposite to that of people in this room. So I take your work very seriously. And I just think that we need, a vocabulary to be able to talk about it where it's not in the past, but rather had a transformative purpose. It was a purpose that may have been betrayed or not applied. And I just wonder if this could be helpful in terms of your, the focus on values and not just a constitution about constraint or structure, and this kind of very formalist discussion. Maybe we should, you want to?
Here's a potential problem.
Okay.
And it's why transition gets complicated. It's why second founding gets complicated. In South Africa and a number of other regimes, they're structured by the notion of, we had a revolution in the ANC. The South African Constitution doesn't want to say, we're hoping to practice traditional South African practices as they were done in 1950 with this thing. We're getting rid of apartheid, but then the rest of the South African government peachy. I take it that's not the South African Constitution. But it's not what they wanted to do. Here is what the Constitution of 1868 is. Republicans, free soilers from about 1830 to 1860, developed a theory of the anti-slavery Constitution. This is what they maintained the Constitution was. As far as they were concerned, slavery was this little bit of, it was like a wart. It wasn't the cancer, it was a wart. The Constitution of Reconstruction excises the wart. What the 14th and 15th Amendment do is they also excise some other warts that grew around the wart. But the idea wasn't that they were creating a fundamentally new regime. Rather, they were reproducing the framing regime as the framing regime was supposed to be. Now, if you were not a Republican in 1850, you had a very different understanding of the Constitution. You did think, my God, this is a revolution. So here is the great paradox of Eric Foner, well, everyone who calls it a second revolution. The people who call it a second revolution, one, favor everything the Republicans did. They wanted to go further, but they're adopting the perspective of the white supremacists because they were the people in 1868 who thought it was a revolution. Just a little paradox for you.
Okay, great. So let's open it up to any remaining thoughts, comments. Yes, Sandy?
Yeah, I'm gonna go back to Henry for a second, where he quoted the vesting clause in Article 2.
So the president must wear a vest to exercise.
But, it does seem, the more I think of it, the more it seems to me both fanciful and probably harmful to think that any constitution shouldn't have a sell-by date. And Aziz Hook, and I think this is relevant to transitional constitutions, that it's a good idea to say, we're going to have this constitution for 25 years because you really don't want to open it up again 3 years later. You want to see how it will work. It is crazy to say, and we should keep this forever. So, my favorite constitutions are the ones that do what they can to generate frequent reflection and choice. So, I like the New York State Constitution because every 20 years you get to vote on whether or not to have a state constitutional convention. John Tyler, believe it or not, actually said that it was a defect of the Constitution that we didn't review it after 50 years. And it seems to me that the problem with putting anything too specific in the Constitution is that it might turn out on reflection to be troublesome, that you want more flexibility. Very last point in this, one of the things I assigned to my class this past week was Greg Abbott's 2016 Texas plan for constitutional reform. And he says, we're really in a bad way because we deviated from the framers. And one of our deviations is that we have this run amok executive. That's not what Greg Abbott is saying in 2024, but it is what Democrats are now saying. But the run amok executive is by and large a creation of the Democratic Party, not of the Republican Party. And what looked like a good idea at time T turns out not to be such a great idea at T1. And that's true of a transitional constitution. And I think it's just a dilemma with believing, as Neil Gorsuch says, that you should write for eternity, that your opinion you write should be good not only for this day only, but it should be good 50 years from now. You should read it with great pride.
Well, here is, one thought. By the way, it turns out time T isn't 20 years. Time T is often 5 years. So it really does, okay, so we're going to have a 3-year constitutional convention to produce something that's going to last 5 years, and then we have to redo it. Might as well keep it as Vermont and Pennsylvania in 1776 had basically an institution that was a permanent constitutional convention. Maybe that's not a bad idea. 2 general thoughts on that. Turns out we have real world experiments. We have lots of countries that change constitutions very frequently, some that don't. My sense is government is no better and no worse than there. So it doesn't seem that changing constitutions help. Here is the one virtue of not changing, and I rather like this, particularly with Governor Abbott. I would rather have a defective system for electing people that is so entrenched that it's next to impossible for incumbents, even incumbents with proto-autocratic ambitions, to get their hands on, then the rule that every coalition that comes into power can change the rules. So, and this is, Sandy knows, I am an arch Burkean and Sandy has more Jeffersonian tendencies. I don't think the Constitution is broken. I think Donald Trump is broken.
We could hold a vote on that, I'm sure.
Yeah. From my very conservative perspective, I think the rules are vague. The structures work to prevent proto-autocrats from entrenching themselves, and that's all you ask. So part of it is, I don't ask about the constitutions.
So should I collect some?
Just hold that,
Collect them?
together,
Yeah, okay, please. Yeah.
I'm curious in terms of changes and revolutions. Is the notion that we went from a system where at least some folks thought they could leave to a system where we said, not only can't you leave, but the stuff that you held dear, you can't do? Did that qualify as a revolution, or is it just the excising of a wart? Because it certainly seems as though the folks from the South would have thought of it to be a real revolution. The folks from the North may have thought that it was a wart. Which one do you go with, and does that matter?
There's several other hands up. Yeah.
So I was curious, you talk about constitutions as setting the mechanisms by which we create interests or politics. But of course, constitutions sit on top of social organizations that are responsive to them and that organize political power around those mechanisms. And so something I'm curious about a little is, so you say that the Reconstruction era folks got the mechanism wrong. But is it possible to get the mechanism right in a way that stands outside of time? And if not, then we're back in maybe Sandy's territory of, do we need to keep refreshing the Constitution? Though, as you point out, that is itself a fraught process.
And I think Garth, did you have your? Okay. Anyone else?
Hopefully this will stop. It's the worst thing.
Any, okay, good, okay.
So in response to Henry, part of what I want to simply say is, from the Republican perspective, it's not really a second founding. Abraham Lincoln says, the framers thought slavery was on the path of ultimate extinction. Okay, the mechanism was a little different than we thought, but yep, it's extinction. We also get rid of a few passages, such as the 3/5 clause, that were the product of slavery. That's it. From other perspectives, it's not. Now, from this book project, I am largely simply saying, here is the perspective of anti-slavery advocates. Just as in the Dred Scott book, I want to say, here is the perspective of pro-slavery constitutionalists and why they thought what they were doing was reasonable and why it's not entirely stupid. A different book, not my style of writing, would say, okay, now adjudicate the fight between anti-slavery Republicans and pro-slavery Democrats. Who was right about the Constitution of 1787? Now, I think there's actually a revolution. But the revolution it actually occurs in the 1830s, and it's entrenched by the 14th Amendment. Namely, we have a constitution that is designed to run and prevent parties. It is a constitution that will work by electing the elite, who in the 1830s get to be called the money power and later the slave power. Now, the Constitution of 1868 is more so, even with the 12th Amendment, designed to be run by political parties. And this is a very important concept in democracy and who's going to rule. And the North, by the way, at this point, Northern politics is not simply free labor, racial equality, it is parties with names. Southern still is not parties name. If I'm a member of a party, it's only temporary, don't worry, when the election is over. So I think that's the revolution. In response to that, I don't think constitutions sit on top of interest groups. I don't know, people here are familiar with the work of William Van W.V.O. Quine. Well, and this is a great influence at Wittgenstein, for those who know Wittgenstein. The idea is, it's not the case that we have higher principles, mid-level principles, lower level principles, facts about the world, and they're ordered like this, rather than one big spider web with complex connections with each other. So I would say the Constitution exists within a framework of different interest groups, different values, a lot of different other things that change the Constitution. You will change everything else in the system. Change the interest groups, you will change the Constitution, but we will learn a lot more about the way constitutions work by not having a constitution, big space, rest of the world, and big circle with lots of things in it, including constitutions.
Well, that's a wonderful image to end this very rich day and a half. So let me join me in thanking Mark,